Charlotte Woodhead possède un diplôme d'avocate. Elle est enseignante-chercheuse à l'Institut juridique de l'Université Warwick en Grande-Bretagne. Ses travaux portent sur le droit concernant l'héritage d'éléments culturels et sur la manière dont s'applique la notion d'héritage culturel dans le droit britannique. Et l'autre aspect de son travail concerne la restitution, le rapatriement d'objets provenant des collections de musées, fondé plus spécialement sur les plaintes qui sont enregistrées pour des objets culturels en Grande-Bretagne. Ce qu'on peut dire, c'est qu'en 2018, elle a été désignée par le ministère de la Culture, Multimédia et des Sports, ainsi que par le Spoliation Advisory Panel, pour rédiger le rapport sur la 3e recommandation du plan d'action de 2017, en conclusion de la réunion qui s'est tenue à Londres. Et depuis 2013, elle est membre du comité d'éthique de l'Association des musées britanniques.
Merci. Thank you very much, and I'd like to start by thanking the organisers for the kind invitation to address you today. Matthäus Weller and I are presenting jointly, setting out a comparative assessment of the work of the 5 different European restitution committees dealing with cultural objects. In terms of outlining our presentation today, I'm going to start by looking at the differences and similarities in the process and some of the substantive principles as well that are applied by the different committees, specifically by undertaking a comparative exercise, looking at situations where the same claimants have brought claims before more than one of the 5 restitution committees and consider the processes and outcomes of those claims. I will then hand over to Matthäus, who will look in more detail at the jurisprudence of some of the decisions of the committees across Europe, focusing in particular on the way in which flight goods or Fluchtgut are dealt with by the different panels. And this presents a real opportunity to look at the way in which decisions are framed. And it will also provide an opportunity for him to talk more about his wider project, which is the restatement of the restitution rules across the committees. So by way of background to what I'll be talking about today, following the London conference in 2017 held at the National Gallery, an action plan was produced aimed at moving forward the development and discussion of restitution for Nazi-era dispossessions of cultural objects. And it seems to me that there are 5 central themes to the action plan. The first of these was identifying differences, both in the provision of information and the processes across the different panels or committees in the different countries. The second was about the transparency of the processes and the provision of information both for researchers but also for potential claimants. Thirdly, identifying and encouraging best practice was key to the action plans, not only within the 5 committees that already have, 5 countries that already have committees, but also more widely as well, encouraging other countries to address the issue of restitution. The 4th element was about training and dedicated provenance researchers. And finally, the 5th element was about focusing on development of future links, some of which we've heard about already today, the development of the network of restitution committees, but also conferences such as this were mentioned in the action plan. Now, to bring forward these action points, the DCMS and the Spoliation Advisory Panel set about researching different aspects of the plan. Tony Baumgartner produced a note focusing on the different definitions used and also the relevance of genealogy and lineage. And I was asked to look at recommendation 3, specifically the differences and ways of harmonising the principles, processes and provision of information. Now, firstly, one of the key differences can be that of historical differences. In some situations, these lead merely to different considerations taken into account by the committees, but in other situations, it can also affect the number of claims that come before the panel. Now, some differences relate to the categories of objects, and this may lead to the need for different responses and different considerations by the panel. For example, in France and the Netherlands, dealing with the MNR collections and the NK collections, and also in Austria as well, the category of objects that were restituted after the war, but then were transferred to museums in exchange for export licenses or in transactions that were closely related. So the law had to develop to deal with those situations. And again, in the Netherlands, dealerships thrived during the Second World War. So there's a different category of claimants, which is particularly prevalent in the Netherlands. And Evelyn Kampfens, in a recent article in Art, Antiquity and Law, highlighted the specific principles that have been brought in the Netherlands. And in the UK, having not been occupied, there were fewer works that entered the UK collections. So this does mean that in reality, fewer claims are heard by the National Committee. The second difference to focus on is the legal differences. And of course, these derive from the fact that we have the common law, the civil law, or federal systems. And this can have implications for the legal structures used, as well as the nature of the collections involved, whether they're federal or state or private collections. And I hope just to focus on the detail of some of these processes here. In France, the Netherlands and the UK, really there are two roles. One is making recommendations to the ministers or the prime ministers or to the individual museums. But the second aspect is also acting as a conciliator or mediator in the event that private parties bring claims before the committees. And of course, in the Netherlands, there's the binding opinion procedure, which then has implications for whether that can be challenged in court afterwards. We heard earlier today, François Bernard talked about the quasi-legal nature of the French system. And I've always called the UK system a quasi-legal approach as well. And we heard earlier today about the way in which the panels or the committees are chaired by judges as well, giving it that quasi-legal nature. Further work, I think, needs to be done on whether there is a perception, certainly by claimants, as to whether justice is done where there is a perception that it is an automatic jurisdiction if a claimant brings a claim that they will be heard, or whether it does depend on mediation, whether it's consensual as well. And I think we've heard that there are changes afoot in the way in which in Germany the claims are heard rather than it being a consensual mediation, although the rules of procedure seem still to show that that consensual mediation is needed. But we've heard that funding may depend on whether or not a museum accepts that a claim should be heard by the committee. Looking now at the scope of the claims, there's a much wider scope to some of the committees than others. So in the case of the Netherlands and Germany, really cultural objects are those that were lost or seized as a result of the Nazis. In Austria, we know that it's about losing possession of those objects in Austria or in any other place under the German sphere of control during the Nazi era. In France as well, the CIVS has a wide jurisdiction to hear claims relating to all sorts of goods, but we've heard about that increased specialisation in cultural objects, and we will hear more about that in the subsequent presentation. In the UK, it's an extremely wide jurisdiction for any loss of possession of cultural objects during the Nazi era. And of course, that meant that in the case of the Beneventon Missal, that was the loss occurred in circumstances unconnected directly to the Nazis. It was during the Allied occupation of Italy. So that is a particularly wide jurisdiction. In terms of the composition of the committees, the work that I did really drew up a number of questions which I think merit further consideration. We've heard that the panels are chaired by judges or former judges, but do the presence of several lawyers or judges on the committees affect the outcome? Tabitha Oost, in a recent International Journal of Cultural Property article, talked about the legalistic and moralistic paradigms in the decisions of the different committees. And I think it would be interesting to look at whether the presence of more lawyers does affect the way in which the methodology of the decisions is handled. And similarly, does the presence of government representatives, either as members of the panel or there in an advisory capacity, affect the way or the outcomes or the way in which it's perceived as a process as well? And similarly, the Secretariat. This was a situation that was raised when we had an independent review in the UK of the Spoliation Advisory Panel, but it was considered that that wasn't an issue because there were definitely sort of barriers between the different departments of the Department for Culture, Media and Sport. I'm going to turn now to the substantive principles, looking at the way in which jurisprudence has built up over time. and how I argued in 2013, looking at the work of the UK Spoliation Advisory Panel, that the principles have developed almost akin to precedent over time and the way in which similar claims might be considered, although each of those decisions are dealt with according to their individual circumstances. Now, one way of looking at the claims is to consider those claims, as I said, where the same claimant has brought claims before more than one of the European restitution committees. I suggest this gives a snapshot. It is not the entire picture. My major caveat here is I have not been directly involved with the claims, either seeing it from the point of view of the claimants or the respondents or as part of the decision-making process. And those who experienced it firsthand may have very different interpretations or perceptions of the process and outcome. And so whilst I identify possible explanations for different outcomes, I'm not saying that those are necessarily justified in the circumstances. And it's really to fully understand the consistency of the principles, we need a project such as Mattéoli's, which is looking across the board at similar factual situations. But I hope that this does give a starting point of comparison today. Now, 11 cases involve the same claimants bringing a claim before more than one committee. I admit I'm not entirely happy with the colour coding I've used because it's quite difficult to reflect the nuances, and I will explain it, I promise. I hope that it gives an overall picture. Two claims, the Woodhead claimants and the Feldman heirs, had claims heard by 3 committees in 3 different countries. The remaining claimants had cases brought before 2 of the committees. I'm going to turn now to the top line, which in these 4 cases, broadly the same outcomes were achieved. The Emma Woodhead claim, it was forced sale, where the heirs did not have free use of the proceeds, and this was resulted in return in all 3 countries. The Berolzheimer case as well, we had return in the 2 countries. And the Franz Koenig's case was unsuccessful, both before the Dutch and the UK panels. The Max Stern case had the same outcome in the sense that return was recommended. However, return in Germany was subject to conditions this year that a sale wouldn't take place for 10 years, in which time possibly a primary victim may come forward, or further research might indicate that restitution was not the way forward and it should return to the museum. But broadly, the outcomes and the remedies were the same in those. Now, the next 2, the Rothberger and Feldman claims, they were successful, but I said that they have different remedies here. In the case of the Rothberger claims, there were slightly different factual scenarios in the sense that in the UK it involved a direct seizure, whereas in the Austrian claims there had been restitution, but then there'd been a transfer after the war to a museum in exchange for an export license or in related transactions. In the UK, in the case of the British Museum, an ex gratia payment was made together with an account of the object's history. This was made purely on the basis that at the time the British Museum did not have the power to transfer the object from the collection. That was remedied with the 2009 Holocaust Return of Cultural Objects Act. And so the UK would have recommended return had it been available at the time. In the case of the Arthur Feldman case, there were slightly different remedies in the different countries. Again, at that time, the British Museum was unable to transfer or deaccession objects within the collection. But interestingly there, return was requested. So, I apologise, sorry. In that case, in the case of the Courthold Institute, a payment of an ex gratia payment and an account of the object's history was requested, but actually return was made because in the circumstances the panel felt that the public benefit derived from using public funds to pay for the object and to keep it in the collection would not have been met. And in the Netherlands as well, it seems that compensation and a commemorative plaque were requested, but actually it seems, unless I've misread something somewhere, that return was actually made in that situation. And in Austria, of course, return is the only available remedy. Looking now just at the 2 cases that have slightly different circumstances of loss, which may explain the difference here. In the Behrens case, in the German Commission, the rejected claim, the sale took place approximately July 1935, but the Commission was of the view that Behrens was freely able to use the proceeds, and no fact suggested that the gallery had failed to pay that sum of money. Whereas in the successful Dutch claim, this took place much later, at some point after May 1938. And at that stage, of course, in 2008, there was the more liberal approach to restitution. There was nothing to suggest that compensation had been paid, and so it was an involuntary loss due to circumstances directly related to the Nazis. And in the Fleckheim case, again, one claim in Germany was for return, another was rejected, and in Austria it was rejected in 2013. The Austrian case, the sale took place before the Netherlands was occupied, and so didn't fall within the framework of the Austrian committee. And the rejected German claim is actually one of those flight good claims that Matthäus will consider. Now, the final three claims have different outcomes. Now, in terms of the Glaser case, I actually put it as slightly the green one in the sense that on paper it may well have seemed a successful claim, but the remedy differed. So in the 2009 decision of the UK Spoliation Advisory Panel, the panel considered and put emphasis on a letter that was written by Dr. Glaser to Munch, which demonstrated the mixed motives for the sale in their view, and that as well as persecution, the sale in 1933 was also due to the fact that he wanted to start a new life. And so it saw as well, it accepted that it was a forced sale, but that it saw both the previous compensation paid to the heirs as well as the fair price at auction as potential double recompense, and felt that the moral claim was insufficiently strong to warrant return, but instead recommended the display of an account of the object's history. Whereas in the Netherlands, this was an object in a state collection, subject to the reverse burden of proof, and return was recommended. The Julius Freund case involved sales in Switzerland, and again, that is flight goods, and I'll leave that for Matthäus to talk about. And in the Oppenheimer claim, in the Netherlands, return was recommended in 3 claims, and a successful claim of a share of the proceeds and a binding opinion. But in the UK, the panel was in receipt of further information, of further evidence, which suggested that the sale was for the repayment of a debt for commercial reasons. So just in terms of some concluding thoughts now, really the importance of provision of information for potential claimants, in terms of how to bring claims, expectations of the process and possible outcomes, to understand why the outcomes might differ between the claimants, the committees, and also the sharing of good practice and the restatement of restitution rules suggests that this is a way of harmonising the criteria. And I now hand over to Matthäus.